It's 11:30, and so we're going to go ahead and start. There are a couple of announcements that we have before we start. Three main things. First off, there was a question in the last webinar regarding concurrent enrollment, and I'm going to push the response to that to the end of this webinar. So anyone that has, because the response is not like 2 minutes, it's more like probably a 5-minute conversation. And so we're going to push that to the end, and anybody that wants to hang out at the end of the webinar will turn off the recording, and then we'll have that conversation regarding concurrent enrollment for institutions that may be interested and have a more concurrent enrollment. The second announcement, in case you missed it, on July the 10th, the Office of Post-Secondary Education for the U.S. Department of Education pushed the Clery publication date for this year to December 31st. Which is normally October. It's been pushed to December 31st for the narrative portion, right, that you have to publish. And interestingly, the data statistics portion, you know, where your president gets the ID and password and then hands it off to whoever actually inputs the data, that data portion is set to open on November the 18th, and it will close on January the 14th of 2021. And so you will have between November 18th and January the 14th to input your data for Clery. And so if you are looking for that, the notice of this, it came out in the Office of Post-Secondary Education's email blast from July the 10th. And the third thing, it was kind of without any uproarious notification, the Texas Attorney General filed a brief in support and in favor of the new Title IX regulations, of which numerous attorney generals signed on, including the one from Oklahoma. And so if you want to read that brief in support of the new Title IX regulations, we've placed that on the Dropbox as well. And so without further ado, we will just jump right in and start. Today we're going to be talking about the investigative process and the hearing process. Aaliyah, I would love it if you could briefly introduce yourself at the start so that everybody gets to know you. They're probably sick of hearing Brandy and I, and I'm so excited that you were able to join us today. So if you could introduce yourself, please.
Oh, certainly. Thank you for asking me to join you. I am the Director of Student Conduct Education Administration at Oklahoma State University. I also serve as the Deputy Title IX Coordinator, and so I've been here for 9.5 years, and so I've been doing Title IX since that day. So 9.5 years ago means I started right before the Dear Colleague letter. So this has been my area of interest and now my area of research. So I'm glad I can share just some resources and how we go about these things here at OSU.
Fantastic. And so both Brandy and Aaliyah and I will be talking with you all today. And so we're going to start with the investigation process. And the first thing we're going to start with is, when does the process formally start? Like, what is your day zero? And your day zero appears to be from the regulations when we have the submission of the formal complaint. Now, you'll remember way back in webinar 1, we talked about the difference between a report and a formal complaint, right? And so that day zero starts whenever we have a formal complaint that's alleging sexual harassment and requesting investigation of the Title IX coordinator or other person that you've deemed to have actual knowledge. I understand that Maxient is having a boot camp at the end of this month. And for those of you all that, I don't get any money from Maxient, okay, so let me just say that right now, but I know many of you all use Maxient, and so if you're using it, that may be something that you want to attend and also look at their Max Stacks, some additional things that they're going to be putting out in August, so that you all can determine how do you want, if you're using Maxient as a reporting tool online, how do you want that report to come in? And if you're not going to have it signed when it first comes in, how can you use their electronic signatures to really make it a formal complaint after you get that first report? So that's really day zero. Aaliyah or Brandy, I'll hand it over to you.
Yeah, so I've put together a number of documents that we use throughout our process. And so I'm going to spend the time that I have today to just walk you through some of those. They are up and open for you to use. They're added onto the Dropbox and in Word, so you can take them and edit them for your institution. And so I think the easiest thing is I'm going to share my screen and go through them with you. So one second here.
I'm going to stop sharing mine.
Okay.
Okay.
Okay. So this document here is right at the beginning of your investigation process. You're going to be meeting with the complainant and later the respondent. And there's a number of things that we have to go over with them. And we've had to do this in the past, especially with VAWA requirements. And so this is to aid you in guiding your conversation with them and making sure you're covering what you need to cover. And so this document we use in those meetings with students and have them identify, yes, we've covered the information, or no, we didn't. And if they mark no, we're going to make sure that we cover it so they can mark yes. And so these are the pieces there that we go over. It references this sexual violence resource booklet. If you're interested in that, that's publicly available on our website at oneistoo-many.okstate.edu. And that is going to align with the aspect that you have to provide all of this information in written form. So you can't just have them sit down and talk to them verbally. You need to provide it in writing, and that's per VAWA. And so that booklet will meet that requirement for you. Going on, you're offering both complainant and respondent the supportive measures, which were talked about in a previous webinar. And these are some of the options that we have in place, and this individual gets to select what they'd like, what they don't want, or maybe I just don't know right now, with the understanding that they could always change their mind. So this could be used at the time in which you do an intake meeting with an individual, or maybe it's the first time you're meeting with a respondent after you started the investigation and you need to go through those supportive measures and offer them just the same as you did the complainant. So that could be used in that sense. I've included this summary of resources. These are the resources we offer to our complainant and respondents. It's a nice quick guide. Anything you can do to provide information in various forms to the individuals is helpful. There's a lot going on with them, and they're trying to gain all this information in a short amount of time. So this just is a quick little rundown. We attach this to our letters. We provide it to them in person when we meet with them. This information is also included in that booklet in a much more in-depth form, but it is a nice little summary, so you could take that and adjust as you see fit. I should mention that many of the documents I provided aren't necessarily perfected for this new process. We're still working on the policy, which has a trickle-down effect into these documents, and so know that there's still going to be pieces we're going to have to update based on the changes we make in our policy. Okay, so as we get to the investigation process and we start that, we have an internal checklist here that we use when we're explaining the process to a complainant and a respondent. I'm a huge fan of checklists and tables. You'll notice there's a table and everything practically, but it's helpful. You know, we do this unfortunately very frequently, and so it's not that I'm getting rusty and I can't remember because it's been a long time before case, but when you are doing something repetitively, you also need a checklist. So I very much encourage the checklist. And so this is not word for word, of course, what we cover with a student, but it's a little reminder on make sure you cover this with a student or the complainant respondent, the people supporting them. Some institutions will make this pages upon pages because they want to put in paragraph form what they're going to share with the complainant about the investigation and how I'm trained as an investigator. We don't necessarily do that, but that is something that you could do if that makes you feel more comfortable that you won't forget anything. So we know that the regulations are confusing to us. And so that means they're going to be confusing to our complainants and respondents. And so this document is new for us, and I'm very excited about it. I think it's going to be very helpful in our communication to complainants and respondents. And so this is an investigation process flow chart. And so as we're communicating from the first meeting on, we can share with the complainant and respondent where we're at in the process. And yes, we have policy documents to share with them, but those can be overwhelming and not always straight and to the point. And so this is an explanation of where we're at. And so we tell them at the first get-go, you can always ask us where we're at in the process. It's not a secret. And every time we progress to the next stage, we're going to be communicating with you. But if you feel that you need more, call us up, let us know. We want to keep you informed. And so this document I plan to use with stakeholders as well. So your counseling services on and off campus, your community partners, making sure they're aware of your new process. This is what I hope they can have and use as a resource if they're supporting one of the individuals in our processes. And so it goes through from when we've received a complaint to now we're at this investigation stage. And who is it that we might be chatting with at that point? I separate out the collection of documentary information. I'll touch on this later, but I think that we tend to combine that all in the investigation meeting mindset, and that tends to lend us to maybe forgetting about the documents that go along and support our investigation. So I separated out intentionally. And as we know that we're going to have follow-up meetings, we're going to have this investigation report we're going to talk about, but then they have this opportunity to review, and we'll talk more about that today, review the report, give feedback, and oh golly, we might have to start all over again if we have this written feedback that says, we have new information. Okay, well then the investigator's going to have to start over again. And so that is a dress that we might have to go back to ultimately square one on this flow chart. Then we end up getting into a hearing process, and so that just outlines our timeline that we currently have set out for these new regulations on what we're going to be doing. So you have all of this to access and read through. But I think this to me is the most exciting piece to be able to provide and explain it. So it's difficult for us. It's going to be even more difficult, I think, for anyone else to understand that does not live this day to day. The other thing I included in here was an investigation notice. It's in draft form by all means. It's, we've taken what we've been using and trying to adapt it to the new situation. But it is something that I think as we finalize our policy, we're still going to have more changes, but it is here for you to at least have a starting point on. If you've never had a notice for a hearing before, might be a little bit helpful to not have to start at square one. Okay, so I think we're transitioning back. I'll stop sharing my screen. Now at the notice.
So one thing I'll add here is a number of the slides today will have the regulatory requirements that you need to know, but we're not going to spend a lot of time going through them because we want you to hear about the practical side, and we know we only have a limited amount of time with you today. So this slide basically covers everything that has to be in your notice. And this is an area that in the past courts have really focused on. What did the institution provide to the respondent in particular? And what the key here is, you've got to have enough detail in there that the respondent knows what it is that they're being accused of and how they are supposed to respond to that. And then in addition, there are a number of policy statements that you need to have in it. So looking at Aaliyah's materials, which I cannot say enough good things about, there's a standard notice in there, and you could use that, insert the standard pieces, and then you only have a few pieces to update each time you send one out. And I've also got to stress one point that Aaliyah made, which is the value of checklists. Cannot overstate the importance and value of consistency in this process. People need to know, one, we need to be transparent and tell them what's going on. And two, we need to be consistent in the way we apply this process. And these forms can really, really help you get there.
So in reflecting on the notice requirement, there's a couple of things you're going to want to think about. First, you're going to provide the notice, and then you're likely going to schedule the interview with the responding party, and they're going to need some time to prepare, as is kind of articulated in the regulations, and you're going to have that interview. And you're probably going to have these interviews before you make determinations regarding either mandatory or permissive dismissals. And And then you're going to continue the process, right? So you may make either a mandatory or permissive dismissal at that point, or determine there is no dismissal available, and therefore you're going to have to likely interview respondents numerous times, because this first interview may be about, whether or not a dismissal is appropriate. And so to the extent that you've had investigations previously where you were really trying to limit the times that you interviewed responding parties, with this new process, that's likely going to become more challenging. Another challenge is the idea of supplemental notice. So if during the investigation you uncover that there's additional allegations, which is a lot what Brandy was talking about, that were not included in the initial notice, you're going to have to provide supplemental notice. And with that supplemental notice will come, a need to likely re-interview and gather additional evidence. And so fortunately, the old 60-day time frame that we saw and that alluded to in many resolutions with OCR and in the 2011 Dear Colleague letter is now quite aspirational and wasn't included in the final regulations, likely acknowledging that this back and forth of notice, interviews, determinations of dismissals, more interviews, supplemental notice, more interviews, right, is really not, and we haven't even gotten to the determination yet, right, is likely not ripe at all for 60 days. So where do informal resolutions fit into any of this? What we know, because that may be an item you've not really embedded into your processes previously. And so informal resolutions, according to the regulation, are available at any time prior to reaching a determination, right? So at any time before your decision maker reaches a determination. I scoured looking for data to figure out about success rates for informal resolutions based upon timing in the Title IX process. And if individuals are working on their master's or PhD and would love to take this up, this will be really interesting data if one could gather it, because I can't find squat out there. That's my technical term. I mean, not anything about the timing of the informal resolution and whether or not you're successful. So then I went on to well, what else would tell us? Because where is the best time to embed informal resolution? If we can do it any time, where are we better off doing it? And what we know about litigation generally is it is better to mediate earlier. So to the extent that we think of informal resolution as not just restorative justice, but also a mediation process, the earlier you do it, the better. And so I've included in the notes section, which I will not bore you with, a number of research-based scholarship about the efficacy of early mediation as a decent intervention, and the success rates the earlier that you are in the process, which may inform where you want to start talking about informal resolution in your process, if you're going to even have that as an option at all. So we can stop right there for a brief pause to see if we have any relevant questions, and then we will move on to interviews and evidence exchanges.
I don't see any questions so far, but Mike Davis raised a good point that the regulations estimate about 25% of cases may resolve by informal methods.
I wonder, did they share any data about how they formed the basis of that conclusion? That is, maybe I'm pondering out loud too much. That is, out of 2,000 pages, that is fascinating. So looking at the interview schedule, what we know is the burden is now clearly on the institution to compile evidence. And you're going to have to allow sufficient times for the parties to prepare and to participate in interviews. And Brandy, will you share with us gathering evidence?
Yeah, so as Mackenzie noted, the burden's on the institution. Interestingly, the regs do very clearly say you can continue using trauma-informed investigative techniques. And they go on to say that the cross-examination that's allowed during the hearing basically, in their view, makes that a fair process. So to the extent you've already done training in trauma-informed investigations, you don't have to move away from that. In fact, we recommend you continue using that. You have to provide an equal opportunity for the parties to present witnesses. That makes a lot of sense. And you also have to look at both inculpatory and exculpatory evidence. And those are legal terms that basically mean inculpatory is things that tend to show somebody's responsible. Exculpatory is something that tends to show that they're not. So something that kind of cuts the other way. And another interesting note in the regs is you cannot tell the parties that they can't talk about what's being investigated. That tends to be a position some want to take so as to not taint the investigative process, and the regs are very clear that we cannot do that. So next we're talking about the right to review evidence. Both parties have to have the opportunity to do that. You have to look at everything that the institution plans to rely on as part of their investigation. And the key takeaway from this slide is the investigator, at the point where the parties are reviewing the evidence, should not take out things that the investigator thinks are not relevant. So basically leave everything in at this point, let the parties take a look at it, and then we'll deal with the relevancy piece of it a little bit later. And the regs basically say they want the parties to be on notice of all the information that's out there, whatever that quote universe of information may be.
And so when we talk about that universe of information, we need to think about there are two pots of pre-hearing evidence sharing opportunities. And that first pot is what I would call the large production pot. It's the universe of evidence that is directly related to the allegations. It is before the investigative report is issued. Okay, so there is the big pot that is the universe that's directly related before the investigative report is issued. And then there is the more narrow production that whenever you create an investigative report that fairly summarizes the relevant evidence, then you have 10 days prior to a hearing, you're going to have that evidence that is shared. So you have the large production set, and then you have the more narrow production. And so this kind of explains that as well. So the nuts and bolts of the issue, how do you share this evidence? The department does not require, nor did they recommend a particular means of sharing. What we know is many institutions, because of the pandemic, have gone to really almost a total remote operation, particularly in the area of Title IX and student conduct. And so you may have already developed an electronic file sharing protocol that you're comfortable with. And if you have, boy, more power to you, because that is something that you could look to see if that meets the regulatory requirements and continue to use that. What the Department of Education says they're really trying to address, and we've put this in the last bullet here, is they wanted to address when you have both parties who sit, quote, in a certain room at the institution's facility for a designated length of time without the ability to take notes or review, and often they were supervised by an administrator. That's not what they want to see, right? So they want to see kind of a full production and allow that the parties must have a copy of the evidence. Now we can choose as an institution to have in our policies that they can not copy it, they cannot disseminate that information. And we can also specify that they can't photograph that or disseminate it to the public. And I put this one quote in here from 3432, that such measures may be used to address sensitive materials such as photographs with nudity. I think that is interesting and instructive on a lot of levels of telling us exactly the extent it is. All that first large production evidently includes, it's going to include everything, including if you have photographs with nudity. You really need to think about what technology you're going to use to provide that information to the parties. And SUNY has created a technology chart where they compared and contrast both the cost and the helpfulness of different technologies to use. And so that's also on the Dropbox as well, as something that you may want to look at whenever you decide what you're going to use. I think we have already discussed this. and brief. Evidence in academic records. If an academic record of a party is directly related to the allegations, then you're going to be able to disclose that to both parties. The example that they gave numerous times in the regulations is about attendance records, but they didn't limit it just to attendance records. And so they talked about if there are academic records that are relevant, you're going to need to make that available to both parties. Also, if there is information that is privileged, that is shared, and you make a determination to not provide that, the regulations talk about needing to make a privilege log. I might suggest, and I put in the notes section on slide 22, an option for an agreement regarding evidence disclosed during a Title IX investigation. And this agreement would be both with the parties and it would be with the advisor, particularly the advisor of choice if the individual chooses an advisor who is not familiar with how this process works. And the agreement covers not only a brief explanation of the regulations, but also that the parties are responsible for their advisor's conduct, a waiver of disclosure to the advisors. It may be that a party does not want this information provided to their advisor, at which point we would need to document that. The evidence sharing process, the security and confidentiality protocols. Ideally, we would really like for people to only look at this on password protected devices and other things. Disability accommodations, the regulations make clear that if we need to provide evidence and a person requests an accommodation for that evidence, that they need to make the Title IX or whoever aware at your institution that evidence can be provided in a format that is accessible. And then also what kind of sanctions there may be if there is a violation of the expectation to not reshare this evidence. And so institutions may choose to put that in a process or a supplementary process or a statement of expectations that they provide to the parties. Many institutions are also looking at that as something more formal, like a written agreement, especially whenever you see use of outside advisors.
Okay, we do have a question. If new evidence or information is submitted during review, then do you allow a follow-up review of additional information shared to both parties? Meaning this process could end up taking 40 days or more alone, if so.
Yes. And I think that the follow-on commentary of this could take a while. Yes. And I think it is worth documenting in your investigative file, either through a timeline process or just through your normal record keeping process, why it is that this is taking more time, because the parties provided evidence and then that needed to be provided to the other parties. That is not the institution has very little influence over that. And so you're going to want to make sure you document that. So that later, if there's ever any question about, why did this process take, 60, 90, I don't know, 4 or 5 months, part of that could be the back and forth. Now, interestingly, OCR has always had in their case processing manual the absolute ability, when they investigate institutions of higher education, to have 180 days in which to complete their investigation, and there is no penalty within the Department of Education if it takes longer than 180 days. And so there's always been this kind of argument that 60 days, it seemed like a quick turnaround in light of other standards that were already used within the Department of Education for similar types of investigations of institutions. And so I think that it is the question is well placed. This may make it take longer. So Aaliyah, I'm going to turn it over to you.
Yeah, some commentary on that. I would say I encourage to get our complainants and respondents against their advisors in the process sooner than later. So we would end up having a whole investigation process, and then they decide to tell maybe their parent, who has no idea they've been alleged of sexual assault, and the hearing's in 5 days. And so I see this being a problem if they were to inform their support network right as they get this investigation report for review, we could be starting off at square one quite frequently. So encouraging that advisor participation on the front end, which is weird that I'm saying that because I usually don't encourage that. I do think it'll help us streamline the process. Okay, Mackenzie, if you want to pop to the next slide for me, I'm not going to switch over for this section. I want to, in the documents, there is a template about the investigation report, but I think what would be most helpful is if I just talk through what we include in these pieces of the report. And so here is just an outline of what you're going to find to be typical categories that are covered in an investigation report. So the first one I'll talk about is the summary of investigation. This is where you can outline who you've talked to, who didn't participate, and though you've reached out however many times. If there were documents that you requested that maybe weren't fulfilled, things that you have done to attempt to get information for this report could be included in the summary of the investigation process. When you're talking about involved parties, you're going to provide just basic information about the complainant and the respondent that might include their role on campus, where they're employed, maybe their major year in school, just the very basics. As far as when you outline the witnesses that you have talked through, a piece to consider is there a direct witness and an indirect witness involved, and what is their relation to the complainant and the respondent? That can play a part of credibility assessment for the decision makers. As far as background information, we typically include how they've known each other, the length of that relationship, any background that you need to understand between the individuals involved for you to understand the concepts of what's happening as we go forward in the reported information. I'm going to cover reported information in the next couple slides, so I'm going to skip over that one as well as the consent chart. And as I mentioned earlier, I think it's very valuable that we think of the materials and the supportive materials that you can collect through your investigation process. I think at times I've seen investigators focus so much on having that meeting, and that investigation really consists of the conversation back and forth between the investigator and the complainant or respondent. And we're not putting enough focus on what other supporting materials are out there. And so maybe we collect it, but our investigation report also needs to document those materials and not just attach them as, oh, here's some text messages or Snapchat videos or something. We need to explore them and explain them within our investigation. So that could mean referencing them throughout your document. If you're talking about it, say, see page, whatever, reference what appendix they're in. We're talking from text messages to saying exams, maybe even employee emails that we are trying to acquire, if there's videos. So I think the other piece is be mindful that you might have to leave your office to aid in that investigation so you can complete this report. So does that mean you have to go take a picture of the space that we're talking about? We can't just sit at our desk and help that investigation report can be done. So think about that. And that's more on the skill set, so I'll leave that there. But you might have to make diagrams, things like that. Let's see, tables are, like I said, I love tables, but I think when you're talking about our documentary information, to have a table of what is the document, what are you referencing, and how is that relevant, and what are you seeing in this document. If it's a video, you should be explaining what's on the video. You shouldn't just hope that the decision maker reviews it, and of course they should, but your report needs to be inclusive of all of those things. And so I've seen that as an area that we forget about from time to time, or maybe don't put enough emphasis on it. So that's why I'm emphasizing it maybe more than the obvious interview that you're going to have with individuals. In the area about information about interactions, we've previously have called this the credibility assessment. We're moving away from a credibility assessment and moving towards just information where we're acknowledging maybe there's this gap in content, or we've taken some efforts to resolve some of the inconsistencies in the report and maybe what we did in those senses. And so there's really not a lot at this point that we are thinking about adding in this section, I think it really has to be a significant thing for us to add something about those interactions. Because the regulations now have the cross-examination process, that's really what all about is about the credibility assessment. That's what the regs are wanting. And so we're not inserting ourselves as investigators going forward in these credibility assessments. And I'll tell you, as an investigator, that's the worst part of the investigation to write. You question yourself. You wake up in the middle of the night trying to think through, have I said that okay? And so I'm glad to get rid of that, and I think that we're going to be in an okay place without it. Another piece that's in those documents for you is there is a letter, a distribution letter that we are going to be utilizing to communicate to both complainants and respondents about the investigation report. So again, it's just a template. We want to ask them to track changes. You have the option for your written response, and so there's a template in there that you can you're welcome to use. So going back to the reported information, I've outlined two options that we utilize in our reports. Again, here's tables, goodness. Remember that you are unbiased in this process, and so this table option is very helpful to compare. Are you accomplishing and sharing the same content and even your word choice when it comes to explaining the information collected from both parties? It can get complicated when you have more than just two parties involved. Of course, having multiple complainants and respondents can change a little bit of what this table looks like, and you might choose option 2 if that was that situation. I encourage, if you when you're done with the report, have a colleague within your department that is within the confidentiality restraints, read through this and see if they're seeing something that's unbiased. Put on your, Karen hat and see if, is there going to be a Karen that has something to say about that? If you don't know what a Karen is, that's in the skill set session, not part of this webinar, because that's just about being current in the current lingo. And then also in these examples, we learned what lapping was. So part of being investigators, learning the new lingo and terms and crazy things that individuals are doing these days. So that's option 1. We're explaining the difference between the individuals' perspectives. You can see here that I don't really put witnesses as a one side or the other side, even though maybe they're best friends with one person or the other. We just list them as overall, here's additional witness information. Option 2, if you want to head on to that one for me. Option 2 is really paragraph form. Let's talk about the complainant's perception of what has occurred and a summary of their information and what we've, what the heck is lapping? Oh, I'll tell you later. That was a question that came in. Okay, then after you do complainant, then you would add the respondent's perspective and then any witnesses. So it's covering not by each section and what's related at certain points of the information, but kind of here's the whole rundown of each person's perspective. In different situations, I would say dictate which option I typically go with. I would say for the most part, because of the situations we have, option 1 is our top option. However, I could see option 2 being more appropriate for sexual harassment cases in the employment context. I just think the flow might work a little bit better, but that's your decision on, as an investigator, how you're going to communicate that to your decision maker. On the next slide, we're talking about consent chart. Totally recognize this is probably majority of student cases, but that is what we talk about in a lot of our cases is consent. And so if we can really dive into what did respondent and complainant say about what was consensual or what was not consensual, it's going to help your decision maker focus in on the relevant information that we're discussing in a hearing and not going into irrelevant things about their basketball or pillowcase they lost or something. And so this helps really just hone in and focus on the issues at hand. Lapping is sitting on another person's lap. You would think it would be more, but every student in this case told us there was lapping. And I was like, this has to be interesting. It's not, but it is very much a common term. So there you go.
Okay.
Brandy, do we have any additional questions before we move on to hearings?
I think Aaliyah covered the one we had, which is what is lapping?
Okay. Fantastic.
I also do have to say, having sat in a lot of these hearings, the first option Aaliyah gave you tends to be the most useful to the decision makers. They can really look at, in a columnar format, what are the important pieces and who said what about those things. And that has really helped streamline the process a lot, I think. So I've got to brag on that report model because it really works. All right, so let's move on to hearings. We're going to kind of speed through the regulatory pieces because Aaliyah has some fantastic information for you about the practicalities of holding a hearing because she has tons of experience there. So first, live hearings are required. We've pretty well covered this and beat it to death. You can have a hearing board or you can have a single individual. The one key on this is your Title IX coordinator cannot be your decision maker. That's kind of the one caveat here. Live hearings also include virtual. That's pretty clear in the regulations, and case law has covered in the past that as long as the parties can see and hear each other, that satisfies due process. You'll hear lawyers complain sometimes about the virtual method because they say, well, my respondent doesn't get a chance to confront his accuser or her accuser, whatever the case may be. This covers that. And then you are required to audio or audio-visual record or create a transcript of the hearing. I would recommend one of the recording options because transcripts are expensive. So you can either have a live transcriptionist or you're going to have to record it and get it transcribed anyway. So that's probably the most reasonable method there. The regulations do allow you to have rules of procedure, and I highly recommend that you do. Have some guidance in place for your parties as they participate. So some easy things to think about. Are you going to let the parties make opening or closing statements? Are you going to have a process for how they object to relevancy in it? Are you going to set reasonable time limitations on a hearing? This is one that's hard because every case is so different. So this is one I may steer away from a set timeline on it. But what you could do is on opening or closing statements, you have a set amount of time for this, 5, 10 minutes, whatever it may be, and kind of streamline a few of those pieces of it. Then are you going to define roles of individuals? The regs say that you can have someone who kind of runs the hearing but isn't the decision maker. That might be really helpful. A person who's handling the technology piece of it, who's kind of directing the parties to where they need to be, those types of things. And another consideration is, are you going to have legal counsel present for your decision maker or decision makers plural, whatever it may be? I can tell you as a matter of practice, we have typically had legal counsel there as an advisor to the panel. I think it's been helpful. Our role is not as a decision maker. In fact, we do stay for deliberations, but we're really there to answer questions about what does the code say? How do we write this up and get our rationale in it, things like that, and answer questions about the process as we go. And then the last one we've talked about already, rules of decorum. That's an absolute must. You've got to have that for your advisors at a minimum and probably for your parties as well.
And so, Brandy, talk to me. Sure. Aaliyah has created some rules of decorum that OSU Stillwater uses. And were those in the last webinar, in the notes?
They were in the notes, and I believe they're also in some of the materials Aaliyah uploaded today. There is a guide for advisors. It does clearly say it has not been updated since these regs. As Aaliyah mentioned, there's a lot, as you all can see. We have a lot of materials. So we're working through trying to update everything, but it at least gives you a starting point for that. Questioning during hearings, fairly straightforward. It has to be done out loud. The one key, and we've talked about it with advisors, is advisors have to do the questioning here, or cross-examination at a minimum. The parties are not allowed to do so. If they choose not to have an advisor for whatever reason, they don't get to cross-examine anybody. The other piece that is going to be a bit cumbersome and clunky about this hearing process is only relevant questions are allowed. Okay, fine. But you have to let the decision maker make that determination. So basically what the regs say is the advisor asks a question, there's kind of a pause or a beat before the party answers, and the decision maker determines, is it relevant and are you going to proceed with that question? So just a little bit of a procedural hiccup in there. You also cannot require a submission of questions before the hearing. And this is because there may be other questions that come up as you go through the hearing or something said that leads to another question. So the regs say you cannot do that.
Would you recommend that if you are the decision maker, that you have a discussion with the parties, maybe in your script or before, about, I'm going to have to make some determinations regarding relevance. And so during cross-examination, before you answer, I need a minute to think.
I think it's something that should probably be covered both as part of the procedural documents you provide to the parties and in your hearing script itself.
I agree.
Your decision makers say it on the record. And that script, and we'll talk about that a little later, it's long and it can be overwhelming, but man, it covers everything that you need. It gets it on the record. So hopefully you never end up in litigation, but if you do, no one can say you didn't cover absolutely everything you needed to do because you followed that script verbatim.
Fantastic.
Next is relevancy determination, and this is a dense slide that I'll let you largely read on your own. One big one is the rape shield. That is in play here. The complainant's prior sexual history cannot be used unless it actually speaks to the allegations at issue, and that's going to be a pretty rare occurrence. The second, and the one that I think is most important here, is if a party or a witness is not going to be at the hearing and submit to cross-examination, the decision maker can't rely on their statement at all. They also can't draw inferences about that. So what that would mean is, let's say a respondent doesn't show up, the decision maker can't assume that that's because the respondent's responsible for the violation. You cannot draw that inference. This is going to be unique because you already have a hearing report or investigation report that covers what a lot of parties said. So we've talked about what do you do? And in essence, you're going to have to instruct your decision maker, kind of like a jury, to disregard information in that report where the party wasn't there for questioning. An option for this to streamline the hearing process and not make it, a 2 or 3 day affair. A recommendation I saw on our professional listserv I think is fantastic is have the party show up, party or witness, verbally confirm on the record that the investigative report fairly and accurately summarizes their statement, and then open it up for cross-examination. So that saves you from having to elicit all of that information from that party again. It's already in the report. They just say, yep, that's what I said, nothing's changed, and then open it up to cross-examination. Another key here, and we'll cover training in depth on Monday, you do have to train your decision makers on relevancy, which is going to be a bit tricky.
So I have a question, Brandy. If we have a investigative report and we expect that the respondent is going to appear, we have every reason to think that's going to happen. And so there's no kind of additional things we could have done before the hearing, right? We come to the hearing and perhaps the individual, the respondent maybe calls or texts the Title IX coordinator and says, I'm not coming. And I don't need to reschedule. It's not a timing thing. I'm not coming. Who is it in that hearing that would then tell the decision maker what parts of the investigative report they should or shouldn't consider? Or is that something that the decision maker should know just because of their training? And is it worth putting on the record anyway? That's
an excellent question to which there's not a right answer. I think it should be probably in your script at the start to say that any information that's in the investigative report by a party who's not here can't be relied upon. Okay. You should train your decision makers. Ideally, I like having a hearing officer there of some sort. That's a method we've used in Stillwater, and have that individual address that maybe with the investigator. Also, if you had your legal counsel or another advisor to the panel there, they could cover that. So there's a lot of ways you could accomplish that, but I do think it's important to have it in the script.
Thank you.
Okay, next is decision makers. So we've already covered can't be the Title IX coordinator. You can use panels. I also want to note here, the regs very specifically say that you can allow student participation in this. And some might ask, why in the world would you do that? Our experience has been students are incredibly helpful on these panels. So ours are structured where we have a faculty member as the chair, staff, and then a student. The students know things like, what is lapping? What does Netflix and chill mean? What is Snapchat? What is Whisper? What are all these different things that, sadly, as I get farther and farther away from college, I know way less of this stuff, which is probably okay. But the older we get, the less we know about what is current lingo, and students have been able to provide some invaluable information there. And in addition, they tend to be harder on their peers than the faculty and staff are usually. So just something to think about, not saying you should or shouldn't, but it's an option if you want it. Your decision maker, decision makers, as the case may be, are under an obligation. They have to ask, or they should ask questions in addition to the parties. If the investigator or the decision maker has questions, they need to ask those. It's their responsibility to make the best determination that they can. So the regs go on to say they have the right and the responsibility to do that. And again, we note here that you can have a hearing officer separate from that decision maker to kind of help guide this process along. And then the last regulatory piece on hearings is your determination of responsibility. This is pretty straightforward. The regs go through explicitly what has to be in it. It has to be in writing, have to identify the specific allegations, describe all your procedural steps, and that can be a template form. You can kind of walk through that and have it ready to go of what's in there. The facts supporting the determination, the conclusions, and then a statement of and the rationale for the result. And this is the hardest part for decision makers to write. You made a decision, but explaining in written words how you got there can be really, really difficult. And one of the things that I would recommend as a practical piece here is once you've compiled all your training materials, have some sample language in there about rationale. And this is something that Leah has done a fantastic job of developing. And then have a binder in the room for your decision maker that has all of that in it. They can flip to that page. They don't have to copy it verbatim, but it gives you just a little bit of language that you can put in there that tends to be consistent and that you can then adapt. But I find this is the piece they have the most trouble with. And one of the biggest points of confusion that I find in these hearings is the difference between intoxication and incapacitation. So having those very clearly defined in those and available to these individuals would be really helpful in that. You've also got to lay out the process for appeal. Again, that should be standard in every single one of these. It doesn't change. And then consistent with VAWA, notify the parties simultaneously of the outcome.
So regarding the determination of responsibility, as a practical matter, when, let's say it's not a single decision maker and that you have a panel and they have sat and they've listened to all of this information and now it's the conclusion of the hearing and they have retired with their just small group to make a determination. And that's going to include a lengthy amount, likely, of deliberation between the panel members. And now we see that they're going to also need to create some kind of written document with findings of fact and the conclusions and the statement of the rationale. Do you think, based upon how many hearings that you all have had, that can all happen in one sitting?
Yeah.
If it can't happen in one sitting, what do you think is the best way for that group to come back together quickly to do this again, like to ponder together?
More often than not, we're able to get it done in one sitting. One practical piece here is student conduct provides us a laptop. So we got a laptop sitting in the room. We pick somebody who's going to type. More often than not, it ends up being the lawyer because nobody else wants to. And we have a form that's preset, and then whoever's in charge just starts typing as people are talking. And then what we do is once we finish, particularly the rationale piece, we read it out loud. Is everybody okay with this? Does everybody agree with this, etc.? There are times where we've had a hearing run up until 6-ish on a Friday night. Your panel loses steam. Everybody's tired. They want to get out of there. So we have had occasions where we might break. In that case, I believe we broke for the weekend and reconvened on Monday morning. The key is don't let a lot of time pass in between. You forget the facts. You forget the details. So my best recommendation is try to get it done. Aaliyah is really good about bringing snacks and drinks for the panels. It kind of encourages them to sit there and just get through it. That's really a nice, I know it sounds ridiculous, but at least they know, hey, we got food, we got snacks, we don't have to leave. So just trying to get people to sit and just get it done is the best method. But if you get pushback, yes, it's absolutely allowable to break and reconvene. Just don't let a lot of time lapse.
With the new technology that we might be using, recognizing we might have some hearings that are virtual, we would have them in the meeting, in the recording, and then enter into some kind of secondary meeting with just the decision makers to ensure the confidentiality of that discussion. Okay.
So before we jump to Aaliyah's pieces, there are two questions. One is, can you expand on what it might look like to have a party not submit to cross-examination? So if a party chooses not to appear, it basically your decision maker has to, and it's an exercise that's difficult to wrap your mind around, your decision maker has to exclude anything they said. They can't rely on anything in the investigative report that party says. So let's say Jane, taking that from Aaliyah's report, Jane made some statements about how much she had to drink, etc., at a party, so maybe her observations weren't as clear. Jane then doesn't appear at the hearing. The decision maker cannot rely on anything Jane said. Basically, you almost have to pretend that it's redacted from the report and was never there. I get that sounds kind of like a circular exercise, but in a courtroom, if any of you watch any courtroom dramas, you'll sometimes hear the judge say that the jury needs to disregard what they just heard because an attorney may have objected and said that can't be on the record. So the jury is supposed to, when they deliberate, pretend they never heard it in the first place. Reality can't unhear or unsee what you already heard or saw, but you're supposed to make your decision absent that. The next question was, so are you saying that you cannot use complainant statements contained in the report if the complainant chooses not to participate in the live hearing? Yes. This is why it's going to make it incredibly rare that the Title IX coordinator will proceed with a complaint without a complainant because you are so limited on what you can use. The other thing I'll add that I did not cover, to the extent you're using documentary evidence, such as a police report or something else that references statements of a party who's not there, the decision maker cannot rely in those statements in that document. Even if they're not in your compiled documentary or investigative report, you cannot rely on those. And yes, the panel did have the report before you knew for certain if someone was going to participate. That's exactly right, which is why I say it's kind of unique, and they'll just have to articulate what their rationale was for the decision and make sure it doesn't rely on those statements.
Looks like a couple more trickled in. Do you want to look at those really quick before we move on to the hearing process?
Cover the last one, or the second to last, and then it says, you mentioned a hearing officer. Can you say a little more about what that role looks like in the new hearing process? I think that's someone who, and Aaliyah might be able to expound a little more on this. What we've done in the past is, that's been helpful, they basically kind of sit at the end of the table, and we'll talk about the physical layout of a room here in a second. They start the recording, cover all of that. They also go through in the script and note different times. Like, so let's say, when did we start cross-examination, note the time in the recording. That's helpful if you get to an appeal. You can kind of send that to your appeal panel to, if there's a specific point you want to hear, to do that. The one thing we had contemplating having this hearing officer make the relevancy determinations, can't do that because the regs say that the decision maker has to do that. Our hope was maybe we could just train, this one or two hearing officer or group, and that's not going to work for us. But really the hearing officer's role is they could enforce the rules of decorum. Let's say somebody gets out of line, they can be the one who handles that instead of your decision maker. So that would be a nice role for that person to fill. So if the exact same evidence is submitted by two people, one of which doesn't submit to cross, evidence submitted by the second party can still be used. Yes, and there's a comment in the regs that specifically speaks to, like if there's a text message exchange between two parties, and it's submitted and one party's there for cross, you can use that text message exchange. You don't have to exclude it for that reason. All right, kick it to Aaliyah.
Okay, I think actually it might be more helpful since we're on this topic if Mackenzie, you can go to the next slide, the hearing setup, and then we'll go backwards to the process. And so this is how we have set up our hearing rooms in this diagram. You can see that we refer to it as the student conduct rep. The hearing officer sits at the end there. And then on one side of the conference room table, when we're in a one-room setup, we have our panel, our 3 panel members that are advised by the university attorney. And then on the other side, we have the complainant, respondent, their advisors, as well as the investigator. And we're specific to put the investigator in between them. Let's put some more space in between the individuals. This allows them to be in the same space, but they're not directly looking at each other. They're down the conference room table. And then as witnesses come in and out throughout the process, they might just sit at the end. And they're only there for the time in which they're presenting information. But with our virtual situation, there might be times in which you are doing multiple rooms, or of course video conferencing, which I'll cover later. We're starting up our third and fourth video conferencing student conduct committee hearings. So we've already had a couple, and so I'll give you some tips on what we've done there. But if you're having two rooms, obviously a complainant and respondent are going to be in separate spaces. However, in fairness, we always stop halfway through and we flip rooms. And so the time in which the complainant is presenting their information, they are in front of the hearing panel. And the questions coming to them are from the respondent are through the video conferencing. And then when the respondent is presenting their information, they are in front of the panel, and the questions coming to them from the complainant are through video conference. And so that is how we've done the two-room setup. Of course, if you had more complainants or respondents, you might have more rooms in video conferencing situation. Some in-person considerations, if that ever happens again in the future that we have in-person situations, some things to keep in mind. People are going to be uncomfortable. And that's the way it is. So confrontation's uncomfortable, and a hearing is a confrontation. You need to do what you can to mitigate any extreme situations, but don't be in the situation that you feel like you have to make everyone feel good and feel comfortable. Step away from any student affairs touchy-feely-ness that you have with that. And you have to realize there is a process in place. And so you do what you can, but don't aim for everyone being comfortable. As far as arrival location, make sure you're not telling everyone to show up in the hearing room because your panel is going to be getting ready, and then all you're going to have are your complainant respondents coming in as maybe your panel is prepping and discussing the situation. And so having them meet in a lobby area, and then if you could also be there to greet them, so they have someone there to greet them, so they're going in different directions. Maybe you're giving them hearing materials at that time. So plan out the arrival location. Don't forget about that, and don't send them to the same spot your panel's prepping at. There's breaks at times throughout hearings, especially if they get longer, and so you have to think about certain things during breaks and the departure time. So I think you should be upfront on that you're going to ask a certain person to leave first. I typically, logistically, am going to have the person closest to the door leave first and let them have a little gap of time as they can get down the hallway versus both participants leaving the room together at the same time and increasing a chance of conflict. You could also ask them to go to different directions, different bathrooms, whatnot. And then if one party stays in the room, keep that audio recording on. If they're in the room with the panel, don't turn that recorder off. So then your panel shouldn't be talking, obviously, about the situation if the recording's on and other people are in there. But if everyone leaves the room, you are welcome to pause the recording. Your panel could discuss if they need to, but if you still have one person in the room, it's best just to leave that on. So that's our hearing setup and what that looks like. I'm going to share screen now to talk about some of the documents that are included. And I'm going to start first. We have another checklist about preparing for the hearing. And so when it's identified that we're at a point of pulling our decision maker or makers together, we have our investigator identify that on who needs to be present in this hearing that's upcoming. And then we, oh, there we go. Oh my, we went all the way to the top. I don't know what happened there. 1 second while I scroll excessively to the section that I was on. All right. Then our person scheduling the hearing, we'd like to have it to be someone separate from the person who's done the investigation. Not always possible. There's a number of things that we consider, and we even have a decision-making chart that we track how we've made a decision on who's sitting on a hearing. Once those individuals have been identified, they're put on here, and we can go forward with identifying space and giving them the hearing file. If you're curious about what's in our hearing file, we've listed out here what we would put in this hearing file. It's more than just the investigation report. And so it's all the supporting materials that you've had throughout the process. We also provide information in a hard copy for them so the hearing file is printed ultimately, obviously not in our virtual worlds today. And then when we go to a hearing, we aren't, necessarily close to our office, so we have everything down to Kleenexes that we need to be taking, so there's no concern about showing up and people are sobbing and you don't have anything to, be courteous and help them out. We've kind of mentioned already the guide for advisors and the decorum that's expected in hearings, and like this says, it has not been updated, but I think it is a pretty advanced place as far as we've done the process in our conduct realm of having advisors participate, so it's not too far off as far as what the expectation and role is of them. Of course, we're going to have to adapt it to require for the cross-examination. I've included a hearing notice. Again, this is a template, so we can just drop the information in. If you use Maxient, you know how to read this better because you kind of get what all of those weird little squirrely things are on there and how custom 1 and 2 work. So this has been a little bit altered because of the regulations, so there is some pieces there to help you get started if you have never used a hearing notice. Okay, so let's talk about the hearing itself and what that looks like. I think the easiest thing for me to do is to go through the script with you. And so I'm going to scroll down to the script and go through that piece. The first piece that I shared with you is, can you see just my document? Everything's, give me a thumbs up. I changed something on my screen. No issues. Okay. So I am going to point out certain pieces. The hearing outline is a brief version of it, very helpful in explaining the process to participants ahead of time. But this is really the rundown of what does a hearing look like. So we've talked about this conduct person sitting in, whoever's running your hearings. We are going to most likely transition to a piece that they're actually reading the script. So that the chair, the faculty member, does not have to focus on, oh, where am I at on this script? And I'm trying to ask questions and get my information to make a decision. And so we think that this will help them. I think that there are times in which complainants and respondents or even advisors ask procedural questions, and they ask it, of course, to the chair. They're the ones that are running the hearing. And so the chair kind of, they do a good type of answering, but they're fumbling through. And so we think if our office is facilitating that and is able to answer those questions directly for them, I think it'll be much more smooth, as well as I think our chairs, our faculty members, or who we use for our chairs, they're going to be jumping up and down that they don't have to do that piece. One less thing for them to have to focus on. So we have everyone introduce themselves, and that's very much directed by reading the script on who goes where, or goes when, excuse me.
Aaliyah, just quickly, there was a note, your screen is minimized somewhat. Can you maximize, like the window shrank some?
Got it. Let me see what I can do. Fixed. Okay, perfect. Okay. So we've done introductions. We do include our honesty statement. When I explain the process, there's ultimately 3 phases. And so those 3 phases are starting with a opening statement. So we read the allegations, we read the script. It's pretty straightforward up to that point. I don't think there's a lot of explanation expanded upon outside of reading this, so everyone knows what's there. We do ask, I guess, a couple questions here I'll point out. Are you aware of the charges issued today, and do you understand them? And did you receive a copy of the information regarding the policy and the process that they're following? So opening statements, these are typically brief in nature, so a few minutes. I don't think they're really life-changing for our decision makers at all. I think the purpose of them is really for our complainant and respondent. We're about to dive into the, mishaps of these individuals' lives, and they are going to feel better if they get to share a little bit about themselves that's not about their wrongdoings. And so if they can be able to share, this is my role at the university, or I'm this student, this is my hope, or, we always get like why they love OSU. So, they get to share that, and it lets them kind of know that the panel knows that I'm human and there's more to me than this incident. And so really it's about making them feel like they're opening up. It's kind of, if you will, a little bit of rapport building in a sense. So you typically do that in an investigation. This kind of allows a little bit of that because they're human. They want to share a little bit about themselves. So that's really what I find the purpose to be throughout the whole process. The complainant goes before the respondent, and that's consistent in all three phases. And so you'll see that if the complainant's the one saying something happened, then they need to be able to explain that before the respondent responds. And so that's the justification for the difference. Presentation of information, you'll see that anything in this script that's highlighted, that's something that we're going to change based on the incident in the case. So that's all that really means. So this is a script that we would, if we had a university investigator involved in the case, we would use this section that's highlighted. And so the information presented here for the investigator, they're going to go first. They're going to show an overview or share that overview of the information they've collected. I think as I work with investigators, this is a difficult piece at times for them to decide, what do I share and not share verbally? You are not reading the investigation report to them. And so I think a training piece needs to be for those investigators. What are they sharing during this time? We typically, I'm going to ask investigators to outline for me, as my staff members, I should say, outline what are you talking about, what are you not talking about. We've even had them practice because we need to balance highlighting the relevant facts, but also there's times as an investigator, you're sharing something not because you think it's relevant, because you know if you don't share it, that the parties are going to go and focus on that issue because you didn't share it. And so it's just a balancing act of how much do I dive into. I would say that our panel does not find the investigators' rendition really necessary. They read the report, they know what it is. And I think if it goes too long, they do start tuning it out. And it's sometimes just for the complainant and respondent. But I will say that both parties in various cases have felt like the investigation report is sufficient, that they have nothing else to share. And so that is a huge piece when it comes to your hearing process. If you can get to a point where you have covered both parties' information and they're like, I got nothing else to say, great. You've done that description of that investigation report to a sufficient level for them. And then you can continue with the hearing with questions. I've talked about the documentary information, make sure that you're referencing that, and that's not just like, oh yeah, and there's a video. Maybe you need to clarify, has everyone seen the video? Has everyone watched it? Or do you need to pull up the video on a screen for everyone to see at that point so we know what has been seen by everyone? Remembering that you are the unbiased individual in this process. So, don't watch an episode of Law and Order before you go into a hearing. You're not the prosecutor. You're sharing the perspectives of both individuals in which you've collected. So keep that in mind. Because if you also are in a role of upholding university policy, you sometimes can get that a little confused. This is not your role at this time. Okay, so after the investigator shares all their information, then the panel can ask them questions, and so can the complainant and respondent. What we encourage is if our panel has questions that are maybe more about the sexual nature of something that they want to clarify in the report, we encourage them to ask that of the investigator. Dear investigator, did you get any more clarity on this particular sexual act in this time frame? And the investigator can explain if they have that information. If they don't, they can always turn to that other party, the students in my situation, and ask, could you give me a little bit more clarity there? I've built the rapport as the investigator with the students, and so if there are questions about my investigation and the information I collected, I'd rather it be asked now versus when the students are or the complainant and respondent are up to answer questions. So it's not a lot of times that happens, but it is a nice little area that I can get more information from the students than maybe someone else because I built that relationship as an investigator. Okay, so the next part of this phase is the complainant and respondent get to share their information. And so we always start with the complainant, like I shared. They're going to be able to share any of their information. That happens in a couple of different ways. Sometimes they share it and it's just their account and they give you the whole rundown of everything. Other times they say, I don't know what else to say. The investigator said it all. It's already in the report. Or if they have an attorney, more likely the attorney's going to ask them questions and they respond to those questions as if they were a witness to their own offense. And so that's the options of what we typically see. Then questions can be asked of them. Again, that has to, we've talked through, the advisor has to be the one that does those questionings or cross-examination, with the chair or the decision maker being the one that decides if the question is relevant or not. Same exact process for the respondent. So we go through that same piece. It does point in here, I should mention that witnesses will come in at the time in which the complainant or the respondent is ready for them. Sometimes that's the first thing they want to be done. Other times it's, let me share my piece and answer your questions, and then I'll bring my witnesses in. Other times it's first, so it could go either way. The last phase is closing statements. Before closing statements, we ask the complainant and the respondent 2 consistent questions. They're listed here. How's the situation affected you? And if found responsible, what would you believe to be appropriate outcome? And so we ask that to both parties, and then we go into closing statements. Again, I feel like closing statements are not really extremely helpful for the panel because we asked those 2 questions. I think if we didn't ask those 2 questions, I might think differently. Again, they're just really for someone to feel like they've had closure in the hearing. It really adds to more of the, okay, we are closing out, you've had your time to share everything, any closing remarks. And so that's what I think is beneficial, is just for the participants more than anything. At the very end, we do allow for the investigator to share anything that was shared in the hearing today that did not align with their previous investigation. So we've had an attorney in town that led to this being the case, and for it to be specifically after the closing statements. And so that is a quick rundown of the hearing script itself. Do you want to pause there for questions? Or I do have video conferencing tidbits to share as well. But
there was one question. What does present the report look like for the investigator?
So the report itself is in the hearing file. That's going to make up a good chunk of the hearing file. But really, it's a summary of the information. So presenting it is pointing out the key pieces. Again, like I said, don't read it. But it's really just highlighting the relevant pieces of the investigation. So video conferencing, like I've shared, we've had some experience with this. We've done hearings in multiple rooms for a long time, but doing it all online is new for us and probably for a lot of us. And so these are just some tips and tricks. We developed an internal policy. We also developed documents for the complainant and respondent to receive on what they can expect and what our expectations are of this video conferencing. So password protected, they're not allowed to have virtual backgrounds. They have to have their video on. We are going to make them kind of like scan the room with their camera, which is always awkward when it's this laptop. They're like trying to like show you the room, but we want to make sure people aren't like hanging out in the corner listening on this hearing, trying to ensure this privacy. If you open back on campus, you could provide them a space to sit in, you know, a conference room on campus and do it, so you wouldn't have to be as concerned about that. Once we're on the conference, video conference, and everybody's joined, we change their names, as I say on here. We also mute them, you know, disable them from chatting or sharing, or even changing their name. We lock the meeting. We've also used breakout rooms a couple of times, so a panel might have some questions for the attorney, and so we can put them in a break room, or for the conduct office. And so the break rooms have been utilized in both hearings, and it's been helpful. So that's just kind of a rundown and a summary of what we've been doing with video conferences.
So 2 follow-up questions. By report, do you mean executive summary? And then the second is, do you recommend a time limit for the investigator similar to the complainant respondent's opening or closing statements that may help the investigator in preparing their summaries?
I think that it's a verbal rendition of an executive summary. It is not a written executive summary for the presentation of the information. What we do is we kind of go through the report with the decision makers, and so they can follow along as we talk about the pieces. We do not put a time limit. I wouldn't recommend it. I think internally, I would not go more than 10 minutes on a summary of the situation. However, some situations need 3 minutes and some need 15. So I think that putting a time limit could hinder an investigator from sharing the information, which I think in the end is helpful for the panel, for the participants, so they know that that information has been laid out. So I wouldn't want to limit it.
Okay. And then the last two pieces we'll cover just quickly are sanctions and remedies, because we're getting close to the end of the time. We want a lot of time for questions. The regulations purposely do not set out what your options are for sanctions. The institution has a lot of flexibility. They get to determine, or you get to determine what you think is appropriate. Don't forget here, though, the VAWA requirements, that you do have to list out what sanctions may be imposed on any act of dating violence, domestic violence, stalking, or sexual assault. So don't lose that piece in this. And another piece that isn't on the slide but is a practical piece is, how do you work in a respondent's prior misconduct through the institution as it may be relevant to sanctioning? So for example, you have a respondent who, it turns out, was found responsible for either Title IX or something else previously. What we have implemented is a process called the magic envelope, and it's the most interesting piece of the day for our decision makers. In the front of the hearing chair's binder is an envelope. It's sealed. It always has something in it, whether it's a blank piece of paper or something that just says this respondent has no prior issues. The reason it's relevant, you don't want your decision maker to be biased in reaching a determination of responsibility, but if the respondent is found responsible, your hearing or your decision maker then needs to consider, as part of the sanction, any prior misconduct by that individual. So the way we do it is, if an individual is found responsible, then as part of the deliberations, the hearing chair opens that envelope. It usually has the transcript and it has any prior history in it, and they can evaluate that. The reason the transcript's important is we've had a number of respondents talk about how important school is to them, and they've just dedicated their lives to it. And then you open the transcript and go, that may not really be the case here. So it can play a factor, but again, and then if there's nothing, there's a blank sheet of paper. So that gives your panel an ability to factor that in, but without using it to reach their determination and be perceived as biased in any way. So that's just the brief note on sanctions. Transcript notations, that's a discussion a lot of schools have had. The department specifically did not take a position on that. So you need to decide, if an individual is found responsible for sexual harassment, what, if at all, what are you going to share with other institutions, if anything? So let's say they transfer. And the department specifically declined to take a position on any of that. So that's an institutional decision as well. And then the last piece is remedies. This is, in essence, supportive measures, but the caveat here is this is after a respondent has already been found responsible, so they can be punitive. Supportive measures, you have to make efforts to make them equal, treat the parties equitably. Here, this is where you're taking steps to help your complainant, but they can be punitive as to the respondent if you find that to be necessary. And as with supportive measures, it is the Title IX coordinator's responsibility to implement remedies. All right, that was a lot of information for everybody. We'll open it up for questions, comments, or to quote Mackenzie, snide remarks.
And then for those who want to talk more about concurrent, we'll hang on for probably 5 minutes after we answer our questions.
So there's a question, can your standard of evidence differ for sanctions? No, whatever standard of evidence you choose has to apply to everything. At least everything that fits into Title IX. Let me clarify that. What about attorneys whose whole strategy is to tear apart the complainant? We've never seen that happen. This is where making sure that your decision maker is trained on relevancy, because before that complainant answers a question, they have to say whether it's relevant or not. And if they're asking just questions that straight attack the complainant that have no relevancy, your decision maker can shut that down as part of that. In addition, I would say if the advisor is getting aggressive in the way that they're asking these, that's where you're either decision maker, if that's who you have in charge of it, or your hearing officer, if you have one there, can step in and refer to the guide for advisors. And again, I think setting expectations up front for advisors has been really helpful for us. Have we seen people who are ridiculous and over the top? Sure, but it's been fairly minimal. And Aaliyah may disagree, lower than what we expected from attorneys. I think parents tend to be really kind of terrible to have in hearings. Students don't want to talk in front of their parent, getting them to say things that they might have said in the investigation, use proper terminology, things like that. It's a lot harder for them to do when their parent's sitting there than when it's an attorney. So the question is, since the general counsel's job is to limit liability for the university, do you have any concerns with them being a legal advisory role to the decision makers? I don't. I think that we serve that purpose in advising the panel. We are limiting our liability by making sure that our advisor or our panels follow the process that they're supposed to follow. Now, what we would do, and by serving in that role, we potentially make ourselves fact witnesses if we end up in litigation later, which would mean we're fortunate we have a big enough office we could screen people out of that. So I could serve as the advisor and end up being a witness, and we could have another attorney actually handle the litigation if it came down to that. So that would be the one concern in having your legal counsel serve in that role.
That looks like we're at the conclusion of our questions. And so thank you all again. For those that want to discuss concurrent and what we might do for concurrent with our policies, I'm going to hang on for 10 minutes and we can talk about that. Otherwise, we will conclude with our webinar on Monday, where we will be talking about training, not only the requirements and the regulations for training, but also providing some resources and thoughts about who needs to be trained and what the timeline might look like, and resources about what you might want to present. So we look forward to seeing you and concluding this on Monday. And for those for concurrent, if you want to hang out, that's great. Thank you so much.